A small introduction from my side. Myself, Prabhakar Pramod Jha, a practicing registered valuer, practicing social auditor, and IBC law consultant. My qualification: BMS Finance, first social auditor of our country, Master of Financial Analysis, MSc, MBA, PG in ADR law, IP exam passed, registered valuer, fellow chartered valuer, AIV, FIIB, independent director registered with the MCA, fellowship from Insurance Institute of India, chartered financial analyst, surveyor and loss assessor exam passed of in fire, marine cargo, and miscellaneous. 3 times continuously received a certificate of merit from IBBI, and having a more than decade of experience in a government company as a managerial capacity, managing more than 1,000 crores of assets in financials, and appeared in a court for land and building related matters. And currently a faculty with a 10 RBO for all 3 asset class, SFA, land and building, and plant and machinery in one committee, as a member in a peer review committee of 1 RBO. This is my small introduction. Now we will cover the principle of insurance and loss assessment. Principle of insurance and loss assessment as per the topic in IBBI. So first we will cover principle of insurance. So this topic given in the IBBI syllabus for land and building and plant and machinery is a principle of insurance and loss assessment. This topic is divided into 2 parts. First part is the principle of insurance and second part loss assessment. So in the first part, we are going to learn what are the principle, what are the basic principle on which whole insurance is working, whole terms and conditions of insurance. If we are not going to follow this principle, then there are chances that insurance companies are going to decline the claim. And second part is the loss assessment. Loss assessment means who will do the loss assessment. Loss assessment means whenever there is a claim in a general insurance, then a professional, independent professional surveyor and loss assessor will be appointed, and that person will do the loss assessment work. And after that, they will submit a report to the insurance company. Then the insurance companies are going to settle the claim. So second part is the loss assessment. First part is the principle of insurance. So in first part, the insurance policy holder need to follow certain basic principle. If they are not going to follow, then the insurance company will going to reject the claim. And second part, loss assessment. Loss assessment need to be done by the qualified surveyor and loss assessor as per section 64 UM of Insurance Act 1938. So in general insurance, this only applicable. For life insurance, this loss assessment not need to be done because we cannot able to value human being. This is applicable only in case of general insurance in fire, marine cargo, miscellaneous, loss of properties, agriculture. So there are various kind of general insurance where the loss assessment need to be done. So first we will cover the basic principle of insurance. So basic principle of insurance like a principle of utmost good faith. That means the policy holder need to give the true information to the insurance company. When we are going to take the policy, we should not hide any material information. We should give the truth information. So this is the basic principle of utmost good faith. Then there is a principle of insurable interest. One by one, we will going to learn the insurable basic principle of insurance. First principle of utmost good faith. In this principle, whatever is the correct information, material information, as a policy holder, it is our duty to declare the truth. We should not give the incorrect information. Suppose you want to buy a life insurance, then as a policy holder, it is your duty to give the correct information. Any pre-existing disease, any bad habits that we have to disclose in the proposal form. Like a person who is suffering from cancer, then they have to disclose this information to the insurance company. And based on that, insurance company will take a call whether to accept the policy or reject the policy. accepting at what extra premium or at a normal premium. So based on our information, the insurance company will take a call. That's why it is mandatory. It is the duty of the policy holder to give the correct information, not hide any information. That is the principle of utmost good faith. Because we know the insurance company, but insurance company don't know us. So they rely on our data, they rely on our given data. So that's why it is our duty to declare the correct information. If later on, if the insurance company come to know that the information given is incorrect, then they having a reason to decline the claim, that they will say that you have not followed the principle of utmost good faith. Second principle is principle of insurable interest. In this principle, insurable interest means legal right to take a policy. This is by two way, like a natural relationship, and second by contractual relationship. So first example of natural relationship, we having a legal right to buy the policy. We having a legal right to cover the policy. A husband having a insurable interest in the life of wife. Wife having a insurable interest in the life of husband. Parents having an insurable interest in the life of children. Children having a insurable interest in the life of parents. So this is a natural. So the parent can able to take the policy in the name of child. Child can able to take the policy in the name of parents. Husband can take the policy in the name of wife. Wife can able to take the policy in the name of husband. This is the insurable interest. That's what they are able to take. Can we able to take the policy in the name of our friend? No, there is no relationship. So we cannot able to take the policy in the name of our friend because of no insurable interest. Then second is a contractual. Employer can able to take the policy in the name of employee. Then trustee can able to take the policy in the name of trust, can able to take the policy in the name of trust. Then company can able to take the policy in the name of their directors. So because of insurable interest, they can able to take the policy. They having a right to cover the policy. So that is the insurable interest. Principle of indemnity. Principle of indemnity, you have to remember two things. First, insurance is not available to make a profit. We will not be able to make a profit out of insurance. Insurance will protect you from the financial losses. So based on this principle, whole insurance company, mostly the general insurance companies work. So, and first condition, as I said, you cannot make a profit out of insurance. Second, whatever is your maximum loss, up to that only the insurance company will pay you. So whatever is your loss, or whatever is the value of property at the time of loss, up to that amount only the insurance company will pay you. So first condition, you cannot make a profit out of insurance. Second, the whatever is the maximum loss, that up to that much only the insurance company will go. This is the basic principle of indemnity. Indemnity having a two parts, subparts, like a principle of subrogation and principle of contribution also. So principle of contribution and subrogation is the part of indemnity. If indemnity is not applicable, then subrogation and contribution also not applicable. So principle of indemnity is not applicable in life insurance and Mediclaim because we cannot able to value the human being. So for that, then how we will able to guess that up to that insurance company will pay up to the amount of loss. So how they are going to calculate the value of loss for a human being case? So that's why this principle of indemnity is not applied for life insurance. In life insurance, then how insurance company give the policy based on the income of the persons. There, suppose the package is 10 lakh rupees. So 10 times, 20 times of the packages is available insurance. That is a fixed benefit plan. So principle of indemnity is a 1 mark questions, like they will ask you it is applied in a which class of insurance? General insurance. Not applied in life insurance and Mediclaim. Principle of subrogation. all the rights of insured got transferred to the insurance company, that is the insurer. So in insurance, there are three parties. First, insurance company. In insurance language, it is called insurer. A person who buying the policy, a normal customer are buying any goods, that is called customer. But in insurance industry, a person who buy the policy, that is called policyholder. In normal, any customer consuming the goods, that is called consumer. Here in insurance, any person risk is covered, that is insured. Sometimes the in policyholder and insured are same. Like suppose I'm a buying policy for myself. In that event, I'm a policyholder also and insured also. So in second example, I'm buying a policy for my child. So I am a policyholder and my child is insured. So all the rights of insured transfer to the insurance company, insurer. That means I will help you with the example like a fidelity insurance is available for the risk of like any employee doing a fraud, taking a cash from the employer office. That risk will be covered. Employee fraud risk will be covered under a fidelity insurance. Employer, one example, employer taken a fidelity insurance and their employee taken a cash from their office of 5 lakh rupees and next day don't resume the office. In that event, the employer filed the claim with the insurance company that my 5 lakh rupees taken by the employee, so please settle the claim. Insurance company given the 5 lakh rupees to the employer because they have taken the policy and paid the premium. Later on, police caught that person, employee, and collected or 5 lakh rupees. Now tell me, this 5 lakh rupees going to whom? Insurance company or employer? So if it is going to employer again, then the employer, there are chances they will make a profit because 5 lakh already taken from insurance company and again 5 lakhs this will take, then they got the 10 lakh rupees. So in any situation, you cannot make a profit. That is the indemnity. So subrogation, due to this subrogation right, all the rights of insured transferred to the insurance company because of principle of subrogations. So here the amount of 5 lakh rupees police will give to the insurance company because of principle of subrogation. Next, principle of contribution. Principle of contributions, when we are holding a multiple policies and then all insurance company will settle according to their sum insured. Let's say of one example, like I store a factory, I store 10 lakh rupees of goods in a factory and taken up insurance without 5 different insurance company. 10 lakh rupees insurance taken from A insurance company, 10 lakhs again from B, C, D, E. So same 5 policy taken, 10 lakh rupees. So insurance taken 50 lakh rupees. Goods store in a factory 10 lakh rupees. But when taken a policy with the B, we have not given the information of A that already taken a policy A of 10 lakh. Otherwise, the B insurance company will not give the policy because there is no risk. All risks are covered by A policy, so they will not give. So the factory owner not given the information to the B insurance company, C, D, F, and they got the 50 lakh insurance. Suppose all goods destroyed by fire, then this employers, factory owner submitted a claim to all 5 insurance company. And do you think that all 5 insurance companies are going to cover the 10 lakh? And if they are going to cover, then they will make a profit of 40 lakh rupees because loss is 10 lakhs and they are claiming from 5 different insurance company 10 lakh rupees. So in that event, they will make a profit. So the insurance is not available to make a profit. This is the basic principle of indemnity, and principle of subrogation and contribution are the part of indemnity. So Here, all insurance company will submit a claim of 2 lakh rupees each. They will not going to settle the claim of 10 lakh rupees. They will all going to submit the all going to give the 2 lakh rupees, because of they will say that you have taken a over insurance. We are going to pay you 2 lakh each because your loss is 10 lakh only. And all insurance companies are going to give. Next, principle of proximate cause. What is the reason for the loss? And the nearest region will be covered, not the remote. Principle of loss minimization. This is the basic principle. Factory owner need to be managed. Risk management principle need to be followed. Like suppose owner taken an insurance policy, same example of goods stored in a factory, 10 lakh rupees. But the owner is thinking that I have taken the policy and I will sit idle. If fire taken places, I will sit idle because I have taken the policy. Insurance companies are going to settle me the claim. So if this information insurance company come to know, then the insurance company will reject the claim, because they will say that you have not followed the principle of loss minimization. You have to assume that you have not taken an insurance. Whatever is your duty, you have to fulfill. You should always take the you should always follow the principle of loss minimization. Even if you have taken a policy, you will assume that you have not taken the policy. So that is the principle of loss minimization. That whenever fire taken place in this example, you have to call to fire brigade. You have to use the fire extinguisher to reduce the impact. You have to segregate the damaged goods from undamaged. So this is a principle of loss minimization. So in one short, I will tell you this is the principle of insurance. In this, first you have to give the true material information to the insurance company. Second, principle of insurable interest, legal right to take the insurance. If there is no insurable interest, then you cannot buy the policy. Principle of indemnity, as I said, it is not whatever is the maximum loss, up to that much the insurance company will pay you. You cannot make a profit out of insurance. Principle of subrogation, all the rights of insured transfer to the insurance company. Principle of contribution, all insurance company will contribute with their percentage of their sum insured. Principle of proximate clause, whatever is the region, the nearest region should be selected. Principle of loss minimizations, we will it is the duty of policyholder to follow the loss minimization procedures. So these are the principles. Now we will cover the second part, principle of utmost good faith. Principle loss minimization covered. Then we will cover the loss assessment work. So a person under section 64 of Insurance Act 1938, a person, surveyor and loss assessor, is a qualified person who will conduct the loss assessment. The license is given by the IRDA, CA, CMA, and or engineer. They are the eligible. They have to give the paper for this surveyor and loss assessor examinations conducted by the Insurance Institute of India. I have already a fellow member of Insurance Institute of India and already passed fire asset class, then marine cargo asset class, and miscellaneous survey asset class. So surveyor role. Loss assessment part to be done by the surveyor. Surveyor is a qualified professionals registered under section 64 of Insurance Act 1938. Surveyor are the independent professionals. Why the surveyors are appointments are important? Because at the time of claim, the policy holder will say that my claim is huge. Insurance company will say that your loss is very less. So there will be dispute. That's why in Insurance Act 1938, they have made the provision for surveyor and loss assessor. Surveyor and loss assessor is an independent professional appointed by the general insurance company for the loss assessment. Why not appointed in life insurance? Because we have not following the indemnity principle. Whatever is the given the fixed benefit plan, in life insurance, the insurance company will straight away settle. But in general insurance, the loss valuation need to be done. After the loss valuation, then based on their report, the insurance companies are going to settle the claim. So surveyors are in a registered valuer. There are 3 asset class: SFA, land and building, and plant and machinery. But in surveyor, in insurance industry, as per Insurance Act 1938 and IRDA rules 1999, there are 8 asset class. So CA are eligible for CA, CM are eligible for 4 departments, and engineers are almost eligible in 6 to 7 departments. So as you are a land and building and plant and machinery valuer, so you are eligible for this. Insurer role, basic role of insurer is like to settle the claim on timely, and second is at the time of when they are coming for policy, you should issue the policy. You should cover the risk. So covering the risk and timely settlement of claim. This is a basic duty of insurer. And in short, timely payment of premium, because at the time of claim, the surveyor and loss assessor will check under section 64 UB of Insurance Act 1938. Surveyor and loss assessor will check that whether you have paid the premium or not. If premium is not paid, policy not forced, straight away they will decline the claim. This insurance is a contract of insurance as per Indian Contract Act 1872. This is like a contingent contract or conditional contract. So contract whereby for consideration one party undertake to compensate other for a loss relating to a particular subject as a result of occurrence of designated hazard. This is a contingent contract definition, but how we will read in a insurance contract, like say the example of fire insurance. A fire insurance whereby for a premium, insurer undertake to compensate the insured for a loss relating to a fire as a result of occurrence of designated few risks like a lightning, burning. These are the designated hazards. Contract. What is the meaning of contract? Contract means agreement enforceable by law. So the contract, as per Indian Contract Act 1872, a contract is an agreement enforceable by law. And these are the essential feature of contract. This will be also applicable in insurance. So in insurance, we have to follow the basic principle, then all the provision of Contract Act 1872 and Insurance Act 1938, then GIC Act 1972 and IRDA Act 1999. So you have to remember all these provisions. So first in insurance industry, first law came Insurance Act 1938. Then after that, they have after we got independence, the first law passed for nationalization of all the life insurance company into one, that is LIC Act 1956. Then GIC Act 1972, and then IRDA Act. After liberalization, privatization, globalization, we signed we passed this IRDA Act, and now the IRDA is regulating this profession. Earlier was as per the Insurance Act 1938, Superintendent of Insurance and Controller of Insurance is regulating this profession. This is the essential of contract: offer, acceptance, free consent of parties, consideration, valid object, competent parties, and intention to create a legal law. So offer and acceptance in insurance, when we are filling the proposal form and giving to the insurance company, that means policyholder is giving offer and insurance company is accepting. Free consent of parties, like the consent should be free, without any correlation, without any fraud, without under any compulsion. Consideration, insurance policyholder is paying the premium and insurance company is covering the risk. Valid contract, yes, insurance is a valid contract. Competent parties, yes, minor cannot be able to take the policy. If the minor want to take a policy, they have to appoint a guardian. So minimum age for the guardian should be 21, and to to do the contract, any person need to be minimum 18. Intention to create a legal obligations. This is also important feature of insurance contract. This is a question based on under insurance. Formula is sum insured divided by value of property multiplied by loss. So if your value of property is 20 lakhs, sum insured is 15 lakhs, that means 5 lakh you have less taken insurance. So in case of loss also, you will get a less amount. So sum insured, that is a 15 lakhs divided by 20 lakhs. So 15 lakhs divided by 20 lakhs multiply by 8 lakhs. So you will get the answer of 6 lakhs. So why 2 lakhs they will not cover? The insurance company will pay only 6 lakhs. They will say that you have taken a 5 lakh less insurance. So your loss out of 8 lakhs, we will pay only 6 lakhs, 2 lakhs you have to bear. So the insured will bear 2 lakhs. The formula is, once again I am repeating, sum insured divided by value of property multiplied by loss.